behalf of our group to express our appreciation of the invitation to present a summary of the key views that we expressed in the memorandum that we submitted to Parliament. We do believe that this is an important part of the lawmaking process, and further, that the issues have not been determined in advance, and that is why we are here to speak to the bill in the hope that significant changes may be made, or if need be, that the whole bill be rejected. Now, Mr. Chair, I would make my submission in the following structure. 1, the constitutional issues implicated by the bill and its provisions. 2, the unfounded premises of and justification for the bill. 3, the absurdity of provisions of the bill and a lack of understanding of the issues that the bill purports to speak to. And finally, my conclusion. Mr. Chair, it is our view that the bill violates Article 1, Clause 1 and 2 of the Constitution, the very first article of the Constitution, now, which the sovereignty of the people of Ghana, in whose name, quote, in whose name and for whose welfare the powers of government are to be exercised in the manner and within the limits laid down in the Constitution. So the powers of government, including legislative powers, are to be exercised only in the manner laid down in the Constitution and within the limits laid down in the Constitution, irrespective of the number of people that may support the piece of legislation. The legislation must meet that first provision, fundamental provision of the Constitution. If it doesn't, by Clause 2 of Article 1, that bill or that legislation is void. It's void. It means it doesn't even exist in law. Now, the combined effect of these two clauses is that the Select Committee and Parliament as a whole has a duty it cannot shirk to ensure that any bill that comes before it, the first thing that it must determine is whether it has been introduced in Parliament in the manner laid down by the Constitution. And if it crosses that hurdle, Parliament and the Select Committee must interrogate and determine whether the bill and its provisions are within the limits, again, laid down in the Constitution. So, if the bill is introduced in a manner that is not laid down in the Constitution, that should be the end of the bill. It should be rejected. This is the force of the Constitution. Again, even if it is introduced in a manner laid down in the Constitution, but it is not, the provisions are not within the limits laid down in the Constitution, it is to that extent void. Our respectful submission here is that the bill has been introduced in Parliament not in the manner laid down in the Constitution. This is because this is a private member's bill. And under Article 108 of the Constitution, 2 and 3, it is the president or his agent who can introduce bills generally in Parliament. And where a bill, however, does not impose a charge on the consolidated funds or any public funds, then it may be introduced by a private member's bill. Now, it is clear from the reading of the provisions of the bill that the bill will impose extensive policing duties on the Ghana Police Service if the bill is to be effectively enforced. Secondly, the bill, with its provisions for so-called therapy and medical treatment, will require, in situations where the person responsible for the assault has no money, will require that the state steps in to provide medical services. These clearly impose costs, charges on the consolidated fund, and therefore ought not to have been introduced by a private member's bill. Yes, it is the case, and we admit that Article 108 states that if, in the opinion of the person presiding, the bill does not impose a charge on the consolidated funds or other public funds. That is the text of the bill, of the law, of the Constitution. However, as we all know, and any discretionary power that is granted any person exercising a public function, like a Speaker of the Parliament, under Article 296 of the Constitution, must be exercised in a reasonable and not non-arbitrary manner and without prejudice. And where it is clear that the Speaker of the Commission of Parliament, as in this case, has exercised his discretion unreasonably by concluding that the bill does not impose a charge on the public funds, when it is obvious and palpable that the bill imposes a charge on the public fund, that decision of the Speaker is by Article 296 of the Constitution unconstitutional. And let us make the point clear that we live in a country under a democratic republic where we are not ruled by men but by law. So the Speaker is not above the Constitution. He is subject to the mandatory provisions of the Constitution. And it is our view that the Speaker violated Article 108 of the Constitution when he allowed such a bill that clearly imposes a charge on public consolidated funds and public funds to be laid before Parliament by. So, that's the first point. Now, Mr. Chair, our position on the bill is that it violates the fundamental human rights provisions of the Constitution. It is, in our view, a measure of the ultra-extremism and totalitarianism of the bill that it somehow succeeds in violating virtually all the fundamental human rights provisions of the bill. Just one bill, one law, somehow has managed to violate every fundamental human rights provision in the bill. What do we mean by that? Now, by stigmatizing in the memoranda the LGBT community as inhuman or a taboo or alien to Ghanaian society, the bill grossly violates Article 12, guaranteeing the fundamental human rights of every person, subject only to respect for the rights and freedoms of others and the public interest. It equally violates Article 17, Clause 1 and 2, on equality of all persons before the law, because it separates LGBT persons as if they were not human beings and seeks to apply an equal law to them. Now, further, the bill seeks to promote customary values and practices, which Article 26(2) of the Constitution prohibits as dehumanizing and injurious to the physical and mental well-being of the person. This bill, Mr. Chair, actually attacks the very personality of LGBTQ persons and dehumanizes them and seeks to cause injury to their person and well-being by the provision that makes them liable to imprisonment upon conviction for their identity or LGBT activities. Again, Mr. Chair, Clause 212 of the bill contravenes the fundamental right to freedom of expression and speech, including media freedom, guaranteed under Article 21(1)(a) of the Constitution. It goes to the absurd extent of criminalizing sympathy for a prohibited act and promotion of support for change of public opinion. The bill criminalizes the promotion of support for change in public opinion with respect to LGBTQ matters, and sanctions that by a term of imprisonment of not less than 5 years and more than 10 years. So where a person exercises his freedom of conscience, freedom of expression, to sympathize with LGBTQ people, the sponsors of this bill want this democratic republic to make that a criminal offense, liable on conviction for a term of imprisonment of 5 years or not more than 10 years. Mr. Chair, this is not the republic that Ghanaians fought for. Now, Clause 15 seeks to disband any association or organization in existence before the bill. And Clause 16 seeks to prohibit the promotion, formation, registration of any organization or association with the purpose of promoting or supporting an act prohibited under the Act. Both clauses are in direct contravention of Article 21(1)(d), which guarantees the right to freedom of assembly, including freedom to take part in processions and demonstrations. So let's take a typical example. Supposing that, as is going on in the country right now, LGBT people are being attacked and beaten up, thrown out of their homes. If this bill became law, they don't have the right to go out and assemble and demonstrate to bring the state's attention to the fact that they are being assaulted. If they did so, there's double jeopardy, because in addition to the fact that they are being beaten and attacked, they would have committed an offense under this act and would be liable on conviction to terms of imprisonment. A lady We are aware that the argument has been made that nowhere in the bill, in the Constitution, is there a reference to sexual orientation, sex identity, and so on. Our question is, the Constitution does not anywhere guarantee the right to sex. But any attempt to deny Ghanaians of their right to sex would be a violation of their human rights. Again, the Constitution does not directly make provision for the right to food, but it is well established within the human right domain that every person has a right to food. And again, the view that there's nowhere in the Constitution where there is a reference, a right to sexual orientation or identity, and so on, can only be made in ignorance of Article 33, Clause 5 of our Constitution, which provides as follows, quote, "The rights, duties, declarations, and guarantees relating to the fundamental human rights and freedoms specifically mentioned in this chapter shall not be regarded as excluding others not specifically mentioned, and which are considered to be inherent in a democracy and intended to secure the freedom and dignity of man." So our view, our contention is that this article, this very important article, provides a broad space for recognition of other fundamental human rights that are not specifically mentioned in the Constitution. And therefore, the argument that the right to sexual orientation or identity or expression of LGBTQ people are not guaranteed under the Constitution falls in the face of Article 33, Clause 4, or this Clause 5 of the Constitution. Mr. Chair, I'll proceed to part 2 of our submission, that the memorandum to the bill premises the bill on a number of unfounded justifications. First is the purported protection of Ghanaian family values. The argument is that the bill is necessary to ensure that the family as a unit and protection of human species are sustained. This premise is, however, not supported by any data, absolutely any data, showing that the family as a unit is threatened by LGBT activities. On the contrary, or that procreation is threatened, the human species is threatened by LGBTQ activities. On the contrary, Mr. Chair, the recent census shows a continuing increase in the population of Ghana. In the population of Ghana, notwithstanding the so-called activities of LGBTQ persons. It shows that the allegation that is a threat to society and procreation is just a scaremongering allegation. It is not founded on any empirical evidence. Again, we will note that adultery, and the impregnation of teenagers by heterosexual males constitutes a far graver threat to family as a unit. This is obviously undeniable. Indeed, the idea of, in the bill, that the family is a lifelong relationship or unit is clearly contradicted by the persistent and regular divorces that are lawful under the laws of Ghana. Okay. Now, the other premise is that the majority of Ghanaians support it based on their cultural values. HIV/AIDS are women, and this is so because they have been affected by male sex. So it is not a woman having sex with another woman that produces HIV. It is through the phallus that HIV is introduced into the woman. So if we are seeking, following the logic of the sponsors of the bill, to protect the country from public health issues, then we should ban sexual relations between men and women. But that is ridiculous. It cannot be the case. But that is the logic of the thinking of the sponsors of the bill. Mr. Chair, we note that in clauses 18 and 22, the sponsors of the bill seek to protect LGBT persons from extrajudicial assaults and to provide medical services. It is our view that if you arrest somebody and tell you that, hey, go to prison or recant and take treatment, you are not giving him a real choice. You are imposing on him the decision either to be forced to go to recant first and then go for so-called treatment. When we cannot even, we are fighting with malaria. We now want to be doing complex exercises of treatment of LGBT people. So that is not freedom. Secondly, we are saying that the attacks that have followed the introduction of the bill on LGBTQ community all over have been met with an eerie silence by the sponsors who are telling us that they are passing the bill to protect them. We have not heard any condemnation from them, not from the churches, not from the mosques. We think that that is unfortunate. And it exposes the hypocrisy of those provisions of the bill. Because we really do know that the Ghana police, without any education about the rights of LGBTQ people, if you're an LGBT person, you go to the police, knowing the tradition, they are not going to pursue with any seriousness any such complaint. Mr. Chair, I would leave the issue of the absurdity of the provisions of the bill for now and conclude by saying that we have demonstrated that the egregious forms in which the bill violates the provisions of the Constitution, especially the fundamental human rights provisions thereof. We have also shown that given the undisputed and significant charges that the bill imposes on the consolidated fund or any public funds, this bill cannot be introduced in Parliament by a private member's bill. We have shown further that the foundations for the introduction of the bill as set out in the memorandum have no empirical basis, not supported by any empirical evidence, apart from the palpably wrong evidence that 18.1% of the people living with HIV/AIDS homosexual. That is that even that data that they sought to use is proven to be false data. We have further shown that the bill conflates and collapses different subjects and persons as LGBTQ persons. For instance, an intersex person. Why do you put him in LGBTQ? Somebody who is born. In fact, they say that everybody, when he's born at birth, is either male or female. And yet, they recognize that there are people who are intersex. And, and yet, the bill targets intersex people. How? Because that's how they are born. Mr. Chair, finally, by the very provisions of the bill, it stokes hate, intolerance, bigotry, and violence against a small and vulnerable minority community in our society. Now, the bill takes away the democratic rights of every Ghanaian because it doesn't only target LGBTQ people. It imposes, for instance, on teachers, parents, even judges, independent constitutional bodies, and so on and so forth, the duty to enforce this bill, even if they do not agree with it, even if they do not agree with the totalitarian thinking that drives this bill. It forces judges to comply with the bill, even if the judge takes the view that the bill is contrary to the Constitution. Again, the bill, by criminalizing any act that seeks to bring about a change in public opinion, makes the bill a bill that cannot be, when it's turned into an act that cannot be amended. This is, with all due respect, ridiculous, Mr. Chair, because even our Constitution can be amended. So why would the sponsors of this bill, 7 or 8 members of Parliament, seek by this bill to override the provisions of the Constitution? Why do they seek? Because if the bill is passed into act, the only way it can be amended is by advocating for change of the bill. And that the bill makes a criminal offense. Indeed, the bill is in very good company with the obnoxious transitional provisions, because that is the only provision under the Constitution that cannot be amended. And this bill is seeking to make the bill, if it's passed into law, a law that cannot be amended. That, Mr. Chair, cannot be sustained under a democratic republic. Again, Mr. Chair, the bill seeks to change in a fundamental way our existing system of criminal jurisprudence, which requires that there should be both an intent and an act to constitute a crime. For example, even if an armed robber comes out in the public and declares, "I'm an armed robber," the police will be very seriously challenged to charge him, prosecute him, and get a conviction. But under this bill, it says that if you come out and say you are gay, you have committed an offense. Just by saying you are gay, it's an offense under this bill. Mr. Chair, we do recognize that Ghana is made up of an overwhelming majority of Christians and Muslims. And Christians and Muslims, by their religious upbringing, may have great abhorrence towards homosexual activity. That is okay. That is their Christian belief. That is their Islamic belief. Even though personally thinking, I don't think it's okay for men and women of God to show such hatred. But that is okay. What is not okay is for us to drive this bill by our private religious conviction and impose on Ghanaians, contrary to the provision guaranteeing the right to freedom of expression, a view of a particular view of what should be accepted in our society. Yes, my time is up, Mr. Chair, and I'll conclude.
Yeah, I'm going to conclude. No.
I'll conclude by saying that in sum, the bill is grossly unconstitutional. There is no legitimate justification for it to be passed into law. It is neither necessary to protect any legitimate public interest or the rights of others. Moreover, it is not reasonable nor proportionate to the non-existent mischief it purportedly seeks to cure, and in fact does little to promote so-called Ghanaian family values. It is the bill and its provisions are, with respect, incurably defective. We accordingly urge the Select Committee on Constitutional and Legal and Parliamentary Affairs to advise Parliament to reject this bill on the grounds set out in this submission.